It was a Tuesday afternoon in a county recorder's office outside Columbus, Ohio, and a woman in her 60s was standing at the counter holding a manila folder with her mother's death certificate inside. She wasn't there to file anything. She was there because a letter had arrived 3 weeks earlier from a unit inside her state's Medicaid agency, a unit most families never hear about until it's too late. And the letter used a phrase she'd never seen before: claim against the estate. Her mother had owned her home outright, no mortgage, paid off in 1994. The house was supposed to be the one thing that passed cleanly to her children, the way it always does in the stories people tell each other about how inheritance works. Instead, the state was informing her that it intended to file a lien against that property for $211,000, the exact cost, dollar for dollar, of the nursing care Medicaid had paid for in her mother's final 4 years of life. Nobody had done anything wrong. No fraud, no missed payment, just a deed that was never changed, and a law that most people don't find out about until the bill arrives. By the end of this video, you'll know exactly what that law says, the 4 specific mistakes that trigger it, and the one exception almost nobody uses correctly. And the last one is the exposure most people already have right now, sitting in their own filing cabinet without knowing it. Before we go further, subscribe to this channel and turn on notifications, because the agencies involved in these programs are not going to send you a warning before this happens. They are legally required to notify you after the fact. Nobody sends a heads up in advance. Here's the pattern I see over and over again in state after state, with families who did everything they thought they were supposed to do. This isn't about people who committed fraud, and it isn't about people who were careless. It's about honest, careful people who lost their homes, their inheritances, or tens of thousands of dollars in benefits because of a form that was never filed, a document that was never updated, or a deadline that came and went without a single notice from the government telling them it existed. There's no siren, no red flag, no letter that says you're about to make a mistake. The system simply processes what's in front of it. And if what's in front of it is incomplete, outdated, or missing entirely, that's what gets acted on. Nobody calls to check. That's the part people don't understand until it happens to them. Let's start with the actual law, because everything in this video traces back to one federal statute that most Americans have never heard of, even though it directly threatens the one asset most families count on passing down: the home. Under federal law, specifically Title 42 of the U.S. Code, Section 1396P, states are required, not permitted, required to seek recovery from the estate of any Medicaid recipient who received long-term care benefits after age 55. This is called the Medicaid Estate Recovery Program, or MERP, and it exists in every single state because federal funding is conditioned on states enforcing it. It doesn't matter if the person qualified for Medicaid fairly, followed every income and asset rule to the letter, and never took a dollar they weren't entitled to. The recovery isn't a penalty for cheating the system. It's a repayment mechanism built directly into the statute itself. And here's a sentence I need you to sit with for a second. Eligibility for Medicaid and protection from estate recovery are 2 completely different things. Qualifying for benefits while you're alive does not protect your home after you die. Those are separate legal questions, decided under separate rules, and conflating them is the single most expensive assumption families make. The agency does not proactively warn you which assets are exposed. It processes the claim against whatever is in the estate when the time comes. And correcting course before that point is entirely the family's responsibility. Nationally, state Medicaid programs recover an estimated $700 million a year through this program. And the overwhelming majority of that comes from a single asset class, the primary residence. Trap 1, the deed that was never changed. Here's the first trap, and it's the most common one I see by a wide margin. A parent owns their home outright. They apply for Medicaid to cover nursing home care. Because at over $10,000 a month for skilled nursing in most states, almost nobody can self-fund that for more than a couple of years. Medicaid approves them because the home is generally an exempt asset while they're alive. Under the federal Medicaid rules governing income and resource limits, primarily codified alongside 42 USC section 1396P, and detailed further in the Code of Federal Regulations at 42 CFR section 435.601. A primary residence is not counted against the asset limit for eligibility purposes, as long as certain conditions are met, including an equity limit that in most states sits between $600,000 and $900,000, depending on the state's election. So the family breathes a sigh of relief. Mom qualifies. The house is safe. They think nobody changes the deed. Nobody talks to an elder law attorney. The house just sits there in mom's name, exactly as it always has. The problem is that exempt for eligibility and protected from recovery are not the same legal status. And this is where I want to introduce you to Carol Denning, 68, a retired school administrator from Dayton, Ohio, whose mother Louise spent 3 years and 8 months in a Medicaid-funded nursing facility before passing away in 2023. Louise's house, a modest 3-bedroom on a quarter-acre appraised at $194,000, had been in the family since 1988 because the deed remained solely in Louise's name until the day she died, and because no protective transfer had been made more than 5 years before she applied for benefits. The state's Medicaid Recovery Unit filed a claim against the estate for the full amount Medicaid had paid on Louise's behalf, $211,340. The house, the only significant asset in the estate, had to be sold to satisfy the claim. Carol received a check for $11,000 after the sale closed and the claim was paid. $11,000 from a house worth nearly $200,000 because the deed itself was the entire exposure. The fix for this, when it's done early enough, involves what's called an irrevocable Medicaid Asset Protection Trust, sometimes shortened to a MAP, or in some states, a properly structured life estate deed filed using your state's version of a transfer on death or enhanced life estate instrument. In Florida, this is specifically called a ladybird deed, and it does something a standard life estate can't. It lets the original owner retain full control, including the right to sell or mortgage the property, while still removing it from the probate estate at death, which in most states removes it from MERP's reach entirely because recovery is generally limited to assets that pass through probate. But, and this is critical, federal law under 42 USC 1396, PESE imposes a 5-year look-back period on asset transfers. If you transfer the home into a trust or change the deed within 5 years of applying for Medicaid, you don't avoid recovery. You trigger a penalty period of ineligibility instead, calculated by dividing the transferred value by your state's average monthly cost of care. This is not a same-day fix. This is a 5-year clock, and every month you wait to start it is a month closer to the exposure becoming permanent. If a parent is currently healthy and simply aging, this is the moment to act, not the moment to care becomes necessary, because by the time care is needed, the 5-year window has almost certainly already closed. Trap 2. The notice that goes to the wrong address. The second trap is quieter, and it's about something almost nobody thinks to check: whether the state Medicaid agency actually has a current correct address on file for the person who has the legal authority to respond on the family's behalf. Under most state implementations of MERP, once a Medicaid recipient dies, the state is required to send a notice of intent to file a claim, and the estate's representative, usually whoever is named, in the will as executor or whoever petitions the probate court, if there's no will, typically has a fixed window, commonly 30 to 90 days, depending on the state, to respond, request a hardship waiver, or dispute the claim's valuation. That window is not extended because you didn't see the letter. It runs from the date of mailing, not the date of reading. This is exactly what happened to Raymond Ostrowski, 74, a retired machinist from Toledo, Ohio, whose father Edward had been in a Medicaid-funded facility for 2 years before passing in early 2024. Edward's Medicaid file still listed an address from nearly a decade earlier, a previous residence he'd moved out of before ever entering the nursing home because nobody had updated it when he transitioned of facilities. The notice of intent went to that old address. Raymond, as executor, never received it. He found out about the claim only when he went to sell his father's condo, valued at $162,000, and the title company's search turned up a Medicaid lien that had already been filed. Because the state, having received no response within the response window, proceeded to formal claim status by default. Raymond spent 4 months and roughly $6,000 in legal fees attempting to reopen the claim on the grounds of improper notice. He ultimately succeeded in getting the claim reduced by about $18,000 through a negotiated hardship adjustment, but the underlying claim, $131,000, stood, and the sale couldn't close until it was resolved. The fix here is almost embarrassingly simple, and it's something every family with a parent in long-term care should do the moment care begins. Contact your state Medicaid agency directly using the phone number printed on your parent's official Medicaid card or approval letter, never a number given to you by an inbound caller, and confirm in writing what mailing address is on file. Then request in writing that the executor or a designated family point of contact be added as an authorized correspondent on the case. Many states allow you to file a form specifically for this, often labeled something like an authorized representative or designated correspondent form, similar in function to the Social Security Administration's SSA 1696 for representative appointments. And having that on file before a death occurs means the notice goes to someone who's actually watching for it. If your state has already sent a notice and you missed the response window, most states still allow a hardship waiver request under provisions modeled on federal guidance requiring states to establish procedures where recovery would work and undo hardship. But that petition has to be filed. It does not happen automatically, and every week that passes after the deadline makes the agency less receptive to granting it. Trap 3. Believing the community spouse exception applies automatically. Trap number 3 catches married couples specifically, and it's dangerous precisely because there's a real, valid protection buried in the law, but people assume it applies automatically when it doesn't. Under federal law, specifically 42 U.S.C. Set S. 1396 R5, when one spouse enters a nursing facility and the other remains living independently, referred to in the statute as the community spouse, the home is protected from estate recovery for LOCDAs. Long as the community spouse is alive and living in it, this is a real and powerful protection. States are barred from pursuing recovery against the home while a surviving spouse occupies it. The mistake families make is assuming this protection is permanent or that it requires no action, when in fact most states, under their own implementing regulations, reopen the recovery claim the moment the surviving spouse either passes away or permanently moves out, whether into their own care facility or to live with an adult child. Take the case of Margaret Villarreal, 71, a retired postal clerk from Toledo whose husband Frank spent the final 18 months of his life in Medicaid-funded memory care before passing in 2022. Because Margaret continued living in their home, no recovery action was taken correctly under the community spouse protection, but 2 years later, Margaret's own health declined, and she moved in with her daughter, planning to rent out the family home for supplemental income. The moment she vacated the property as her primary residence, it lost its protected status, and the state reopened the original claim tied to Frank's care, $178,000. Because Margaret was still alive, the claim technically attached against her interest in the property rather than an estate. But functionally, it meant she couldn't rent, refinance, or sell the home without first resolving a six-figure lien that she genuinely had not known was still sitting there, dormant, for 2 full years. The fix requires proactive planning before the community spouse ever considers moving, not after. A properly drafted spousal transfer, moving the home's title fully into the surviving spouse's name, which is explicitly permitted without triggering the 5-year look-back penalty under the spousal exception, written directly into 42 U.S.C. 1396 PC 2B closes, which this exposure permanently because once the home belongs solely to the community spouse, it's the community spouse's estate plan, not the original recipient's, that governs what happens to it afterward. This transfer should be done as early as possible after the first spouse is approved for benefits. Filed through your county recorder's office with a new deed and confirmed in writing with your state Medicaid agency's estate recovery unit. So there's a clean paper trail showing the exemption was properly perfected rather than left to expire quietly. So here's what I want you to do. The exemptions, the breaks, the refunds, most seniors already qualify for but never claim. I've put them all in one place, state by state, form by form, so you don't waste hours digging through government sites. Everything's laid out fast and simple so any senior can find exactly what applies to them. No matter what state you're in, there's money you're leaving on the table. It's called the Senior Exemption Playbook. It's in the first pinned comment right below this video. Just tap it once and you'll have everything you need. Now, stay right here because the last trap is the most dangerous one in this entire video, and it's the reason I made this whole video in the first place. Trap 4. The small estate exemption nobody files for correctly. This last one is the exposure I mentioned at the very beginning, the one most families already have sitting in a drawer without knowing it. And it's dangerous for a specific reason. It involves an exemption that actually exists, that actually works, and that most families lose anyway simply because nobody files the paperwork to claim it in time. Almost every state's Medicaid estate recovery statute includes a hardship exemption or a small estate exemption modeled on the federal directive under Section 1396 PB3 requiring states to waive recovery where it would cause undue hardship, and separately, most states exempt estates below a certain dollar threshold from probate-based recovery entirely, often somewhere between $15,000 and $50,000 in total estate value, depending on the state's own probate code. The problem is that this exemption is not self-executing. Nobody at the state agency reviews an estate and says, "Oh, this qualifies. We'll waive it." The family, specifically, the executor or personal representative, has to affirmatively file a hardship waiver application, usually within a tight window after the notice of intent is received, and has to provide documentation proving the estate qualifies. Things like proof that an adult child sibling lived in the home continuously for the 2 years prior to the parent's institutionalization, providing care that delayed the need for nursing facility placement, which under federal law at 42 U.S.C. 1396 PB2A creates a specific caregiver exemption that bars recovery against that home entirely, permanently, regardless of the claim amount. This is exactly what almost happened to Dorothy Kessler, 82, a retired nurse from Toledo. I want to walk you through this one carefully because it shows both how bad this can get and how completely it can be fixed. Dorothy's son, Michael, 56, had moved back into her home 11 years earlier following his divorce, and for the last 3 of those years, before Dorothy entered a Medicaid-funded facility, he had been her primary caregiver, managing her medications, cooking her meals, driving her to appointments, keeping her out of a nursing home years longer than she otherwise could have stayed independent. When Dorothy passed away after 14 months in care, the state filed a claim for $96,000 against her home, the only asset in her estate. And Michael, grieving and completely unaware this exemption existed, nearly let the response window close without acting. He found out about the caregiver child exemption 4 days before the deadline from a conversation with a friend. not from any notice the state sent him. He scrambled to pull together documentation, his own tax records showing his address matched hers for the prior 3 years. A signed letter from Dorothy's primary care physician confirming his caregiving role delayed her nursing home placement, and utility bills in his name at the property going back to well before her institutionalization. He filed the exemption request 4 days before the deadline. It was approved. The full $96,000 claim was waived permanently, and Michael retained full ownership of the home, free and clear, 4 days. That's the entire margin between Michael keeping his mother's home outright and losing it to satisfy a claim that federal law never actually allowed the state to collect in the first place. If only someone had told him the exemption existed before the deadline nearly ran out. This is why I made this video. This exemption sits in federal law itself, not some obscure state regulation, and it is routinely lost by families who simply never learn it exists until it's almost too late, or until it's already too late completely. If an adult child has lived with and cared for a parent for 2 years or more before that parent entered a nursing facility, that fact needs to be documented now, in writing, with dated proof, tax returns, utility bills, a letter from the treating physician, regardless of whether a Medicaid application has even been filed yet, because the burden of proof falls entirely on the family, and the agency will not go looking for evidence that helps you. Here's your action protocol, and I want you to follow these steps in order because the sequence matters. Step 1. Locate the deed to any property owned by an aging parent and confirm in writing whose name is currently on the title. Call your county recorder's office directly using the number listed on their official government website, not a number from a search result or an inbound call, and request a current copy of the deed. Step 2. If your parent is currently healthy and not yet receiving long-term care, contact an elder law attorney, specifically one who practices Medicaid planning, not a general estate attorney, and begin the conversation about an irrevocable trust or an enhanced life estate deed immediately, because the 5-year look-back clock under 42 USC 1396 PC only helps you if it's already run by the time care becomes necessary. Step 3. If a parent is already receiving Medicaid-funded care, call your state Medicaid agency using the number printed directly on their Medicaid card or approval letter and request in writing that you be added as an authorized representative or designated correspondent on their case file so that any future notice of intent is sent somewhere. It will actually be seen. Step 4. If you are or have been a caregiver living with a parent for 2 years or more prior to their entering care, gather your documentation now. 3 years of tax returns showing a matching address, utility bills in your name at that address, and if possible, a letter from the parent's physician describing your caregiving role, and place it in a single folder labeled clearly because you may need to produce it on short notice. Step 5. If a parent has already passed away and you've received any letter from a state Medicaid agency referencing an estate claim, do not ignore it and do not assume it will resolve itself. Contact a probate or elder law attorney within the first 2 weeks, because response windows in most states run between 30 and 90 days from the date of mailing, not the date you open the envelope. Step 6. Gather the core documents. Every one of these situations requires, regardless of which stage you're in, the death certificate, the marriage certificate if applicable, the original deed, and the most recent property tax statement, because every single form in this process asks for at least one of these. And hunting for them after a deadline starts running costs you days you don't have. Back in that recorder's office outside Columbus, Carol Denning eventually got her $11,000, closed the folder, and drove home to a house that was no longer her mother's and never really became hers either. What happened to her wasn't a punishment, and it wasn't a mistake in the way we usually use that word. Nobody broke a rule. The rule simply ran its course quietly, the way it's designed to, on a piece of paper. Nobody thought to update. That's the whole lesson in this video, distilled down to one sentence. The law does not wait for you to find out about it, it only waits for you to act. If there's a deed sitting in a drawer somewhere with a parent's name on it and nothing else, that's not a settled matter. That's an open one. Handle it while there's still time on the clock.